something the Law Commission did look at. They said, should the status of the individual matter in terms of whether they would or wouldn't pay marriage value? I mean, another political point is to consider what happens if we've got lots of people with short leases in central London who've got flats worth millions and millions of pounds. If they have marriage value switched off in the calculation, they're being handed a benefit, a very significant one. So, there are lots of political considerations which are for government ultimately to consider.
Welcome to Listen Without Prejudice, your exclusive gateway to one of London's leading law firms. In each episode, we dive deep into the stories, insights, and expertise that make Bishop Sewell a trusted name in the legal community. Join us as we explore everything from the latest legal trends and case studies to practical advice on residential and commercial property, corporate and commercial law, employment, family and divorce matters, private clients, and dispute resolution. Whether you're a legal professional, a client, or simply curious about the law, Listen Without Prejudice is here to inform, inspire, and engage. Now, without further ado, let's get the conversation started.
Hello and welcome back to the Bishop Sewell podcast. As always, I'm the Hound of Holborn, Charlie Davidson, if you're feeling sexy, and I'm joined by Mr. Mark Check.
Section 42 at the moment, but they haven't reformed any of the relevant provisions, but it could change.
Mark, is time money?
Good question, Charlie. Philosophical one.
You're probably wondering why I'm asking such an open question. We're talking about the current state of reform for valuations in terms of lease extensions, which sounds very dry and very boring, and you're here to tell me why it actually really
let's
matters.
Start with your question. So time definitely is money when it comes to lease length, because as the lease gets shorter, the cost of extending the lease or buying the freehold will definitely go up. So in that sense, you're buying a diminishing asset and you've got something which is going to become more expensive to do something with in the future. There will come a tipping point. The watch point at the minute is 80 years, because if the lease slips under 80 years, you'll pay something called marriage value in the calculation. It's not possible to give a general piece of guidance around that, but it will be a significant increase in the likely cost it might, making as much as a half or indeed a third more expensive as it otherwise would be. And I don't propose to do a lecture on the valuation mechanism itself. But I think what is worth thinking about is changes which are coming up, which the Leasehold and Freehold Reform Act promises to remove this so-called marriage value from the calculation, which means if you're buying a leasehold property now, you've got a bit of a discussion point to have. I mean, you're telling people all day, every day about this.
It's very difficult because back before all the reforms started, it was merely theoretical. Before it hit the statute books, you knew marriage value, you knew the crunch points, where to advise the client and say you need to get this done before then, before this moment, before this becomes more expensive because your lender will insist on it. Now we find ourselves in a weird grey area where marriage value is still on the books, but may or may not soon, later, midterm, be removed or not removed or replaced by something entirely different. And you find yourself in the middle of a road and you don't know whether to go left or right. And the difficulty is on how to advise clients on that, because we don't 100% know where we're going to be in this end of this parliament.
No, we don't. I think more importantly, actually, everybody's individual circumstances are different. So what's right for them might not be right for someone else as well. That's the important point here when we're talking about this time question and when to act or when not to act. But let's just say a couple of words about where we are right now with this. So the Leasehold and Freehold Reform Act 2024 envisages a new world in which marriage value won't be a factor in the calculation. That's a significant discount. It's a significant win for tenants. It's a significant lose for landlords. It's a shift of value from one set of private property owners to another. It's a political decision. It comes as a result of the Law Commission's terms of reference for the reform of the law in this area, which were some of the most political terms of reference ever given to the Law Commission by Parliament. The Law Commission recognised that, and when they produced their report back in 2020, they said, we're only going to give you options for reform. We won't tell you what to do. You said make it cheaper and easier. That's something we can get behind. We can give you ideas on that, but we won't give you the menu of things. We'll give you a menu, but you must make the choices yourself. So what the government's chosen to do, and it was the previous administration in the Leasehold and Freehold Reform Act 2024, is to basically remove marriage value from the calculation. It's not abolished because it's actually a concept. It will still exist. It just won't be payable anymore. So it will represent a significant discount to leaseholders. And at the moment, that kicks in when the lease slips below 80 years. So the question is, when will that change come into effect? Well, you might say the Leasehold and Freehold Reform Act on the statute books. There's been some moves made to bring it into effect. Why are we not seeing it now? Two reasons, really. First of which is that there needs to be further consultation done on some of the other parts of the calculation before those changes can be brought into effect. The capitalisation rate, and the deferment rate both need to be decided upon. And the government has promised to consult on those before it does something about that. The second point is a bigger point, which is that there are currently 6 Human Rights Act challenges brought by freeholders, who include a wide variety of different sorts of private property owners who own significant freehold interests, from charities to ground rent owners, who are bringing a challenge for judicial review on the decision to implement the legislation itself.
Hold on. Did you say human rights?
I did say human rights, Charlie, yes.
What is human right? Well, when I think human rights, I think, children in cages being deported, or, freedom of expression, or, being able to protest outside our offices. Not protesting us, they have to go past us to get to Parliament. So what's the Human Rights Act got to do with removing marriage value?
I'm glad you asked me that question. So Article 1, Protocol 1 of the European Convention on Human Rights, to which we are a signatory, provides that you have the right to enjoy your property without undue interference. And that right actually extends to corporations. It's a general right in relation to all property. So when states want to take action to try to amend things, perhaps to protect the consumer or indeed to protect other members of society, there's a balancing act between what might be called the control of use of that asset and then perhaps taking that control so far that it actually deprives all of the person who owns it of all value. So in short, human rights law does definitely apply here, whatever one thinks about that. And if you want to live in an open democracy, everybody should have those rights, be they a freeholder, be they a leaseholder, and the law should be applied equally and fairly to all people. So the challenges are on the basis that the removal of marriage value itself is such a significant shift in value that it shouldn't be done.
How much value are we talking here?
We are talking literally billions of pounds. We're talking about very, very, very significant sums of money in government terms. And it's one of the reasons the government needs to tread carefully with this, because were these changes to be enacted and were the legislation to be successfully challenged, apart from remedying the legislation itself, it might also be the case that the government might be asked to pay compensation. And of course, the government's not in a particular mood at the moment to start handing out tax money back to private individuals if that's not necessary. So I think the government wants to balance this up very, very carefully. So whilst the government won't mention this overtly, perhaps, as why they are moving more slowly with this aspect of the reforms, it's clear that these challenges need to play out before we know whether the significant value shift around removing marriage value can be brought into effect.
Well, I'm picturing, the evil landlord freeholder getting fat off the ground rents and the marriage value waiting for it to happen. I'm seeing a chap wearing gold medallions, probably with his 12th wife, on a yacht somewhere in the Caribbean, smoking cigars, and he couldn't care less about the leaseholders in Croydon, of which he is the freeholder of, though. I take it that's not a fair generalization of all landlords.
It probably isn't, because there are plenty of people. For instance, let's give another fictionalized example of somebody who's a group of leaseholders who bought their own freehold and they own the reversion to a short lease interest where they have paid a significant amount of money, perhaps in anticipation of receiving back this marriage value, or someone who's got a single freehold and it's in their pension. These people's values are going to be interrupted as well. So I think the point is that the law has to be applied evenly to everybody. It's something the Law Commission did look at. They said, should the status of the individual matter in terms of whether they would or wouldn't pay marriage value? I mean, another political point is to consider what happens if we've got lots of people with short leases in central London who've got flats worth millions and millions of pounds. If they have marriage value switched off in the calculation, they're being handed a benefit, a very significant one. So, there are lots of political considerations which are for government ultimately to consider and for democracy to consider more widely. But what we're faced with now is a situation where, because of the challenges, we're not entirely sure when these valuation changes will come into effect. So to bring it back to our clients and people who might want to take action now, the question would be, well, do I do this now? And how long is it going to be until these changes come in? Now, on one level, that's how long is a piece of string. We cannot say with certainty. But what seems reasonably realistic is that these changes are going to be about 12 to 18 months at the earliest from the mid of the summer, because there needs to be a consultation on the rates. That's going to take 6 months plus. We need the litigation to play out. Now, this application for judicial review is just in relation to the passing of legislation itself. It's on the basis that the implementation or the projected implementation of the legislation is causing loss. If it were to be enacted, there could be a whole load of other cases in relation to the actual losses incurred. And there could also be the opportunity of an appeal if one side or the other feels there are legal grounds for appeal once there's been an initial decision. And that decision is not likely until, the case is not going to be heard till July. And we know how the wheels of justice move. It's more likely that decision is going to be issued in the autumn at the earliest, I would imagine. It's a decision of the High Court.
I mean, given the numbers involved, the stakeholders involved and the history involved, meaning basically mucking around with leasehold law, which is 100 years old, would it be fair to say that this is at some point going to land on the Supreme Court's desk?
I think it's pretty fair to say it could end up there, potentially. Yes. I mean, it's something that could move on, and it could also go to Europe as well, because, of course, this is something which would have, an external jurisdiction as well, potentially once the superior courts in the UK have been exhausted. So it is something that could take some time. And I think perhaps that's the point which people on the day-to-day have to have in mind. Of course, if your lease is very, very long and you're not near the 80-year watch point, perhaps you can say, I can wait. But if your lease is under 80 years or approaching 80 years, or you need to sell or remortgage, you may take the view that you simply need to take action now, because the actual likely timeline on these projected reforms is too far off for you to be able to wait. But of course, that's very subjective. It's not possible to give a sweeping generalization. You can't ring up afterwards and say that Mark and Charlie said I should or shouldn't do this, because you would have to instruct us, and we'd have to understand your position, and you'd have to understand your position, because we can't tell the individual what to do.
It is the most loyally and most common answer that we can ever give to any question we're given, which is simply, it depends.
The other one is, I'm not you. So what would you do in this situation? Well, I'm not you. And unless I know everything about your situation, I only can hypothecate about what I might do. But I've got to give you a choice. These are commercial decisions at the end of the day.
And it's not something you can just do via a solicitor, though. I mean, obviously, we're talking about valuations here, so often you go to a decent valuer.
Indeed, absolutely. So maybe let's make that clear as well. Whilst there is a lease extension calculator on our website, which you can have a look at to give yourself general guidance, you're going to need a properly qualified surveyor who can give you advice about the likely premium. And that depends on a number of factors: the ground rent, the lease length, and the actual value of the property itself as well. So yes, if someone wants to talk to us about that, we will definitely recommend they work in concert with an appropriately qualified valuer surveyor.
One of the many reasons Bishop and Sewell is at the forefront of leasehold property is because, unfortunately, we find this stuff interesting.
We do indeed.
Mark, thank you very much.
Thank you, Charlie.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial, or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and challenges across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.